Other 19-year-olds who don't do this, they get to go to bed when they want, wake up when they want, eat what they want, work out when they want. You don't get to do those things anymore because you committed a felony offense. And if you continue to act like you've been acting and not follow the rules, however insignificant you think those rules are, you're going to end up right back in here and you're going to end up going to prison for up to 10 years. Do you understand? Yes. So your life, you have to make some mature decisions as a young person who's probably not ready to make those decisions. It's going to be a conscious effort and a decision on your part to either do it or not do it, right? What's going to happen if I follow this is you're going to go to ISF. ISF is a 90-day program that's intended to help you make better decisions. But let me tell you what can happen. Between now and the time that you go to ISF, you're going to be in jail. If I get an incident report, it's a violation of your probation. You could get revoked off your probation before you ever go to ISF. Do you understand? And it's happened. Ask them out there. I'm tired of you young people acting like you're acting at our jail. They're tired of it. These people are just going to do their jobs, trying to go home, go with their families, make a living, pay their bills, something that you hopefully will want to do at some point in your life. Instead, they got to go to jail and deal with this. The crap from you kids. But now you're an adult for these purposes. If you get to ISF and you don't make it through that program, or I get incident reports from ISF, they send me those, you're not going to get out. You're never going to see the light of day again. You're going to go to prison. It's that serious. Do you understand? Okay. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. Again, if you do everything you're supposed to, this is a great opportunity today. I don't want it to all be negative because you have some very positive things. You don't have a felony conviction on your record. If you're a convicted felon, it changes your life in so many negative ways. You're not going to get certain jobs. If you want to go to trade schools or school or anything like that, or college, you're not going to be able to do certain things, live certain places, all of that. So you still have that opportunity. And if you get everything together and you follow the rules, at the end of your probation period, the case is dismissed. You will never have a felony conviction. This is the chance of your lifetime to change it and live like the rest of us live, okay? The other side, though, is if you violate any condition of probation, you'll be brought back into court. You'll be found guilty, so you would be a convicted felon, and then the punishment can be anywhere in that range from 2 years up to 10 years in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Again, I know there's other people out there, there's other young people that are acting up. It's going to be up to you to say, I'm not doing it. I don't want to go to prison. All right? All right, you can go back with the bailiff. Yes, ma'am. Hold on a second.
Before he goes, Judge, in light of the fact that you are giving him an opportunity after deferred on the felony in reviewing of his incident reports from the PSI himself and his juvenile history, which is quite extensive.
Yes.
It is my intention to proceed, obviously, with a plea bargain offer on those misdemeanors, but I think it would be important, at least with several of them, to have those on his record so that if he is back, kind of know what we're going to do.
So you won't be able to go to ISF until you take care of those misdemeanors. They'll bring you over on a jail day to get those taken care of. Ms. Molfino will talk to that prosecutor. If you enter pleas on those, great. If you decide to go to trial, then you'll just have to wait to go to ISF until those take care of with the trial, okay? Also, I do want to make sure a condition of your probation is that you are not allowed to be in the possession of a firearm of any type. That means in a vehicle with anybody with a firearm. That means at a house where there are firearms. You are not allowed to be anywhere where there's firearms. If you're living somewhere where there's firearms, you either cannot live there or they have to have those out of the house or locked where you cannot have access to them. Do you understand?
Yes.
Okay, you go back with the bailiff. All right, you're Taylor Douglas.
Yes, ma'am.
And Mr. Douglas was previously in court, entered a plea of guilty to the third-degree felony offense of obstruction or retaliation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have none.
Any additions or corrections?
No, Your Honor.
Only that court is inclined to follow judge and certainly concur with the answer.
In addition, I have received, and you guys should have been given copies of jail incident reports. Have you all reviewed those as well?
We have none.
I'm not, but I take your word for it.
Okay. You don't like to follow rules, do you?
I follow the rules.
You do? You've been following the rules since you've been in jail? Kinda. Okay. So how have you not followed the rules?
I don't know, just whenever, I say like whenever I get disrespected or something like that,
Oh, so when they disrespect you,
I just,
why do you think you deserve their respect?
cause I don't do nothing to disrespect them.
You don't? You don't? Sitting on the countertops, not getting down. Looks like trying to smoke in the bathroom, working out when you're not supposed to be working out, lying about it, saying you're brushing your teeth, teasing and cutting up with and being disrespectful, talking about the officers, act like a little kid. Taking food when you're not supposed to. Calling them some lovely names. B word. Telling them they're white and ugly.
That's what they said, I said?
Mm-hmm.
I don't know, I don't remember.
You don't remember saying that? So here's the thing, how old are you?
19.
19. So you're now on a felony, or about to be, if I follow the agreement, which I don't have to do. You're about to be on a felony probation where you have to follow rules whether you like them or not because you've committed a felony offense. So you don't get to make all the decisions for yourself anymore, right?
Yes,
Step down. Michael Dyer, Mr. Rojas. Good morning. Are you Michael Dyer?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Dyer, in cause number 25, DCCR 1340, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from September 9th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Dyer is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand that?
Yeah.
And do you want to reject that offer and have your case set for trial?
Well, he told me that I have to sign it today because I was gonna get another lawyer.
So here's the thing. Today, I just need to know, there's a couple of things. We'll take them in order. First of all, I need to know if you want to enter a plea of guilty and take the 15 years, or if you want to plead not guilty and go to trial. Okay, so I'll do the rejection and we'll get your case set for trial, okay? Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial quicker. Is that okay with you?
Is it the same thing? I still gotta go to trial no matter?
Yeah. I mean, either you plead guilty and take the deal or you go to trial.
I guess I go to trial.
And are you okay if I appoint a new attorney today?
I guess I can go with this one.
You want to keep Mr. Rojas? All right, so Mr. Rojas will begin preparation for trial and we'll get it set for trial. You may go back with the bailiff. Sarah Jordan,
I don't know what to get her, Judge. She says she's gonna either hire Mr. Kimler or Mr. Smith with one more resetting.
okay, we'll just do a reset on Sarah Jordan's 2 cases then. And Roderick Randall, the sentencing. I'm about to have to take a break.
We came for a sentencing before, you rejected that because it's some new cases. We have a new plea.
Oh, okay, got it. Okay, so
No, they're not new cases in this court, no, but he picked up some new cases.
okay, so we already went through. All right, are you Roderick Randall?
He's not.
And so did I just reset it or did I?
Hi.
What?
So in August, Your Honor, he pled true, and I think at that time we were looking at ISF as our agreement. It was reset for an updated report. Then we discovered he had
Yeah.
2 new misdemeanors that occurred in August. And So I
Right.
filed a first amended motion October 22nd.
Okay,
So
but we need to go through
We need to
that.
get pleased to that, and then we have an agreement that the court's okay with.
Okay. All right. Will he waive the formal reading of the motion?
He will, Your Honor.
Mr. Randall, in clause number 24, DCCR 0543, I have a first amended motion to revoke your unadjudicated probation. And we're going to start kind of all over. I know we've gone through some of this, but we're going to get pleas of true or not true again on all of
And
them.
Your Honor, with your permission, we've agreed to plead a 1, 2, 3, and then the amended counts of 10 and 11, which covered the several new offenses on
Right.
misdemeanors, but
Thank you. So it shows you were placed on probation October 7th of 2024 for aggravated robbery, and that was a 5-year deferred probation. Is that correct? The state's elected to proceed on counts 1, 2, 3, 10, and 11. Count 1 alleges that you violated your probation by committing the new offense of unlawful carrying a weapon May 3rd of 2025. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of evading arrest or detention May 3rd of 2025. And is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025. And is that true or not true?
True.
Count 10 alleges that you committed the offense of unlawful carrying a weapon July 13th of 2025. And is that true or not true?
True.
And then count 11 alleges that you committed the offense of evading arrest or detention July 13th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have paperwork now, again, on the case here that has your signature on it that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State Tender's number 1.
No objection.
It's admitted. Any evidence that Mr. Randall's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of robbery, aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institution.
Judge, I feel like we may have originally pled him to the lesser.
I think we did lesser
robbery.
included.
Let me double check. And it may be because he's one of several co-defendants in that case, and I know at least one of them was pled to a lesser.
I have that we did plead him to a lesser included robbery back in August of '24.
That's correct, Judge. I'm looking at the PSI.
Let me double check with the paperwork, though. Hold on just a second. Can you pull up the original? Well, never mind. It'll probably be in here. Never mind. Hold on.
It was put down to Judge Robbery.
Okay. Does the state want to?
Yes, Your Honor, I'd ask that I be allowed to amend the motion to take out aggravated and reflect the original.
Any objection to that?
No objection.
So I'm going to go back, and just to make sure the record's clear, what you're on probation for is the lesser included offense of the second degree felony offense of robbery. So it's not aggravated, it's the second degree felony. And I'm going to make that modification amendment here on the motion with, let's see. I can figure out how to get all this done. Okay, so that being said, I'm going to find you guilty based on the pleas of true to counts 1, 2, 3, 10, and 11. Find you guilty of the offense of robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
All right, court's just going to, I just need about a 5-10 minute break. We'll be in short recess.
All right, court's in recess.
And this is 25 DCCR 0108, 0109, and 0110. Mr. Bell's cases are set for trial to begin with jury selection on December the 1st. And what is the announcement?
Ready, Your Honor.
State's ready.
Has there been any change? It looks like that last plea bargain rejection was from May. And any change in negotiation or offers?
What was the offer back then? It's currently 20 on the table. I'm not sure what the offer was back then.
It's coming. Hold
It
on.
was 20, Judge, and it,
Okay.
I assume it will be Mr. Smith.
This shows 25 for habitual,
Okay.
and so was there something different?
I think we
that-
went down to 20.
There was a
Let me just-
20-year offer that
Yeah.
was previously rejected to proceed on non-habitual, which
Okay.
Obviously, a trial will proceed on habitual and 4A.
So I want to make sure you understand, Mr. Bell, that the offer that the state has given is to go on, I guess probably count 1 and 2 instead of all of the counts that would make it a habitual offender for a 20-year term in prison. You have every right, again, not to take that and go to trial in a couple of weeks, but I do want to make sure you understand that after today, I will not accept that plea agreement. If you're found guilty and if those prior convictions are true, it means that your habitual status and the minimum punishment would be 25 years. Do you understand? All right, and you want to go forward with trial? All right, we'll get the cases numbered after docket and let you guys know as soon as docket's over. You can go back with the bailiff. Bless you.
Judge,
Yes, sir. Mr. Burbank, on Brandon Bell?
We'll just have a second.
Sure.
I'm like 2 of those after.
Okay, on Williams as well?
Yes, sir.
Ms. Perazo, on Traven Alexander? Sure, yes, ma'am. Well, okay. Mr. Parker, are you ready on Jamarian Martin? It's a sentencing. Jamarian Martin. Okay.
The PSI's really huge now. PSI.
See, I haven't seen this whole packet. I just saw this, I guess. Not that it matters. It's all that's what they need.
And they're all underlined now. I don't know if you've noticed that.
What do you mean?
Like every sentence is underlined. They would like that yesterday. I don't know if yours is, and I didn't.
Mine's not been like that at
Oh,
all.
the 2 dozen?
Well, they emailed me last week and then they got hard copies. And so it's.
That's weird looking. I don't know why. Okay, are you Jamarian Martin? And Mr. Martin was previously in court and cause number 25 DCCR 0196, entered a plea of guilty to burglary of a building. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Any additions or corrections?
Nowhere, Judge.
Only that the state would request $500 in restitution, Judge. I think my conversation with the PSI author in this case, Ms. Banks, was subsequent to her already sending it to the court. So we were able to determine it's $500 in restitution.
Okay.
And I would also ask if the court is inclined to follow it, that it be with a condition of ISF at the very least.
So that's, yes. So my biggest question is, with regard to ISF, it's either substance or cognitive. And so because there's some drug issues, but there's also, he's young. And so what I'm considering is ISF cognitive and then JCDI as when he gets out. Does that seem appropriate for what we've got here?
I think so, Judge.
I think so. He came to court and tested positive last time, but
Right.
it probably would better address both with both of those programs. And then we can always follow up with state.
Yeah. Well, or, yeah.
Let's not go that route.
Okay, Mr. Martin, what I'm going to do, how old are you? 19. So my goal here today, and everyone's goal, is for you to be able to be successful. And so what's going to happen is you're going to be given some tools up front, not necessarily meant to be punishment, but meant to give you everything you need to change your life and be successful and go through this probation. So what that means, though, is if I do all of this now and then you violate later, coming back in and asking for another chance is probably not going to go very well. You understand? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. I am going to order $500 in restitution and that you follow all of the rules and conditions of probation. That's going to include entering and successfully completing the cognitive track of the ISF program, which is a 90-day program to help you make better decisions. And then when you get out, you're going to be ordered to enter and successfully complete the JCDI program, which is the Jefferson County Drug Intervention Program. That is an outpatient treatment program, but it's intensive and it's meant to help you get off all the drugs and things like that. So you're going to be able to be hopefully making better decisions, not using drug. And if you do all of that, this is an excellent opportunity because you're not a convicted felon. You don't have this felony conviction on your record. And if you successfully complete the probation, you will never have a felony conviction. The case will be dismissed at the end if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, convicted of the offense, which means you would be a convicted felon and sent to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. Sorry. Jesse Griffin, Mr. Parker?
Your Honor, before you get him out, I was going to ask for a reset on that. I've talked to him. He has a new offer. He wanted to tell me some things and want to go more with me. He's a homeless guy that he just asked if I could give him more time. I think it might benefit moving the case.
All right, any issues? No. All right, we'll just do a normal reset on, let's see. Jesse Griffin. We're going to reset. Cecilia Delaney, that's a competency. Cecilia Delaney.
She's not,
Oh, is she not?
She should be.
Oh, she should? Oh, okay. Okay. Well, I didn't think they had her. She I just assumed she wasn't, but she said she was here.
Okay.
She's in her.
She is here. Yeah.
She's in our jail. So I'll hold, if you can see, we've got to get that competency thing done. Yes, ma'am.
Huh?
You don't know that one?
What?
She's not here.
She's not here.
They're gonna work on getting her.
Thank you, ma'am. And so let's see, Khalil Harris.
Rejection, Judge. He's right here.
Khalil Harris. I don't see anything on here. Okay. Good morning. Are you Khalil Bradley Harris? And let's see. It says it's locked. There it goes. Never mind. All right, sir. In cause number 25, DCCR 1334, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from August 10th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? Yes, ma'am. And I'm assuming we've got the prior offense. So with regard to enhancements for trial purposes.
They haven't enhanced it, but they could.
So
That's been a discussion.
y'all have talked about this. So is there just the one prior felony?
Yes.
And is it a regular felony?
Yes,
or?
it's a regular felony.
So I want to make sure you understand if you go to trial and you're found guilty, that because you have a prior felony conviction, it would enhance your punishment to that of a second-degree felony, which means between 2 years and up to 20 years. Do you understand? Yes, ma'am. And I have a plea bargain rejection here on the tablet that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 5 years, which means you would leave your punishment up to me. I couldn't give you more than 5 years. I could give you 5, I could give you less. It would depend on the information that was brought to me at a hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
I do also want to make sure you understand that after today, unless there's some new information that comes to light that your attorney or the state's attorney does not know, I will not accept this plea agreement after today. Do you understand? Okay, so we'll get it set for trial. Mr. Harris, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney to begin preparation for trial a little quicker. Is that okay with you?
So you,
Well, it's up to you.
you can do one or go ahead and no.
Okay, well, Mr. Parker will remain on and begin preparation for trial then. All right, you can go back with the bailiff. Corey Balsamo,
Balsamo.
Corey Baltimore.
Mr. Paperwork.
Should be.
Yeah. Waiting for you, Judge.
Oh.
Good morning. We're going to have to get them printed first real quick.
I was like, what?
No,
That wasn't hard. Two years. Let's take it.
Who's Erica here on? Erica Bursch. Okay. Are y'all ready on it? Okay. All right, sir, you are Corey Balsamo, or Balsamo. Will your client waive the formal reading of the motion?
Well, Your Honor.
In cause number 20-34743, I have a motion to revoke your community supervision. Shows that you were placed on probation November 29th of 2021 for the offense of theft of service, a state jail felony. And that must have been enhanced because it was a 10-year sentence that was probated for 10 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to avoid places or persons of disreputable or harmful character, and that you were admitted using methamphetamines within the Abundance Living Facility with another resident. And is that true or not true? True or not true? True. Count 2 alleges that you provided a urine sample August 18th of 2025 that tested positive for methamphetamine. And is that true or not true?
Your Honor, state would waive counts 3 and 4.
All right, did you enter your pleas of true to counts 1 and,
There's 5.
oh, I'm sorry, I didn't see.
We're waiving 3 and 4.
Gotcha.
Not 5.
Thank you. Count 5 alleges that you failed to successfully complete the SafeP program. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 1, 2, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
I see the problem.
Okay. It's a 10 over 10.
10 over 10, and it's,
He was enhanced and it was already convicted, so we can't do state jail.
I missed that, Judge. That's my mistake.
So I have to delete this paperwork because it would have to be TDC.
2 years TDC.
Y'all go, and the paperwork's gone, we'll go back through this in a minute. All right. Let's see, Mr. Lewis, on Christian Montoya Lazo.
Yes, ma'am.
Ms. Burge? Good morning, ma'am. If you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God?
Yes, Judge.
Thank you.
It's court. It's like an August case.
Okay.
And that's what he's being held on here in Harris County.
Yeah, he has a whole.
Burglary. And an ice detainer. Yeah.
Good morning. Are you Christian Lazo?
Yes.
And Mr. Lazo, in cause number 25, DCCR 1423, you're charged with aggravated robbery from May 25th of 2025. And Mr. Lewis, what is the announcement?
Judge, I've talked to Mr. Lazo briefly about the case, but there are some other issues he has out of county that he has.
To visit with the Harris County Attorney and Mr. Nichols, and then go out and visit with Mr. Lazo. And we'll see if we can get an announcement at the next court date.
Sure, Judge.
Thank you, Your Honor.
Thank you, Ms. Bursch. Denzel Spikes, Mr. Lewis.
Judge, hold on, I know Mr. Hopper was looking at that one.
Okay, I'll hold it. Robert Eaglin,
Yes,
it's a
ma'am, Judge.
bond hearing.
Robert Eaglin?
All right, sir, you are Robert Eaglin? And give me just a second. Mr. Eaglin is charged with aggravated assault on a family member with a deadly weapon, and Mr. Lewis has filed a motion asking that his bond be reduced. The bond is currently, let's see,
It was 150.
what is it set at now? Do y'all know?
I think 150.
150. And it looks like there was we were set for trial, and there was the state requested a continuance, and so Mr. Lewis has filed this motion to reduce bond. Ms. Malfino, what is the state's position?
Yes, Judge, the state did file a formal written motion to bring it before the court. I certainly understand that Mr. Eaglin via Mr. Lewis certainly entitled to ask for bond reduction based upon that announcement. Where I am is that the complainant in this case, if the court will recall, it was originally handled in CDC. She was unable to be located. So although the often stated in the indictment looks old, he has not been in custody for that length of time. So I'd like you to take that into consideration. She has recently had a stroke. She is still in recovery for that medical condition. I spoke with her on the phone. She's always been very attentive in reaching out to us. It's difficult. Her mobility is severely limited. Her speech is still limited based on that stroke. And for that reason, I would ask the court to consider allowing for a continuance off of that December 8th docket, and so that we could know in advance so she doesn't have to leave her rehab facility. And I've discussed that with Mr. Lewis, who's always been very courteous about it. I understand the necessity for him to ask for a bond.
Sure. Mr. Lewis?
And Judge, that parcel's cut, that involves, of course, the length of time that he did sit in custody while he was in this case was pending over in CDC. And I think it was a very lengthy time, almost 3 years is what he was in custody for before that case was dismissed, because they could not locate her. Shortly after that, of course, it was refiled. He's been in custody all of this time. We were ready to go to trial because the stroke happened right before the last trial setting. And I think, we discussed it at that point, which I was gonna, and this was the first update we've gotten that she's still dealing with the rehab and everything.
Okay. So,
And typically, Judge would know not to ask more than once. It's just a very severe medical condition.
sure,
and
yeah,
very
no, I'm
serious
going to grant the
aggravating
motion for continuance, but in turn, I think I'm required under
Yes.
17151 to do something with regard to the bond. So I want to get some specific information from you, Mr. Eaglin, so that I know conditions to place on that bond. Where will you live if you make bond?
With my mother,
What is her name?
Marvel,
Marva
Eaglin,
Eaglin, okay, and what is that address?
3705 East Lucas Drive.
'Cause that's here in Beaumont,
Yes.
okay. As far as you know, Ms. Molfino, obviously there will be some restrictions and no contacts. Was there any issue that you know of when Mr. Eaglin was out from the time that case was dismissed until the case was refiled with any type of contact or threats or communication with the complaining witness?
Not that I'm personally aware of, Judge. I certainly would be happy to talk to Mr. Laird about it. I know that the complainant at the present time is very concerned for her safety, just based upon the aggravated nature of the offense, and I don't feel like it's necessary to show the court the pictures of that, but I think you would probably.
I'm looking at the
agree.
probable cause, so it's an allegation of being stabbed multiple times?
Her throat was slit, yeah.
Okay.
Again, I certainly understand the bond requirement and would ask that in the event he does postpone, that he have to wear a GPS at all times so that we can monitor his whereabouts. I know the complainant's whereabouts. I would like him not to know that. And also for him to remain in Jefferson County, specifically in Belmont. He also has a prior felony conviction.
I'm sorry?
He also has a prior felony conviction.
Okay. All right, so here's what I'm going to do, based on the, my granting that motion for continuance. I am going to grant the motion under 17.151 to reduce the bond as well in Mr. Eaglin's case. I'm going to reduce your bond to $25,000 in your case. There are going to be several conditions that are extremely important. The first is that you will be required to wear a GPS monitoring device at all times. You will be on house arrest except for employment with my permission. So if you have opportunities to get employment, you need to get with Mr. Lewis. He'll let me know. All it takes is an email and I can approve or not, things like that. Also, obviously you can come to court and you can visit with your attorney, medical doctors, things like that. But other than that, you are to be on house arrest at 3705 East Lucas here in Beaumont. You're not to leave Beaumont. You are going to be restricted to live and work in Beaumont, Texas. Do you understand those restrictions?
I can speak now. I'm trying to change venue, motion to change venue because this case is prejudiced and it's been dismissed and it's been brought up 20 days later while I was out there helping my dying mother. I didn't do it the first time.
Okay, so here's the thing, you got a lawyer, a motion to change, all right, you're not
I
getting,
wrote the state bar about it and I'm.
your motion to
trying
change,
get some-
all right, listen,
I'm
your
just
motion,
trying to get something
listen,
done.
don't talk over me, okay, because I can change my mind real quick on what I just
I'm
did.
not even trying to bond out, ma'am. I'm trying to get out of the county with this case so that this case can get.
That's denied, your case is going to be here in this court with me, okay?
Yeah, I understand.
So,
But I don't need a bond though.
then I'm going to withdraw everything that I just said. I'm going to deny the motion for bond reduction. And so what we'll do is just reset the case on the next available trial docket and we'll move forward with trial. Go back with the bailiff.
And Judge, that's what I was going to say. How can you evaluate it?
Okay.
Because At the last time I saw him, we were fine.
Okay.
Then all of a sudden, he stopped wanting to visit with me.
Okay,
So-
just send something over and we'll get it taken care of. I know, okay. If you don't want to do it. I made all kinds of good notes here. Russell Bean, Mr. Lewis.
Yes, ma'am, Judge. And if we can hold on that, we have
Sure.
an agreement worked out.
Okay,
But he's gonna need to go plea on the misdemeanor cases first.
okay,
I was just waiting for Mr. Cole to get here. He's his attorney.
gotcha. And then Dijon Banks.
Thanks. That one, I've talked to Ms. Malfino about. There's a lot of discovery on that one.
Okay,
And that we still need to.
so you need some more.
Yeah.
We're gonna reset Dijon Banks and hold Russell Bean. It sounds like he might need to, at some point, go down the hall. I mean.
Thanks, Judge. At some point, I may ask the court for your assistance in procuring some school records of the young child in this
Okay.
case. There's some autism involved, and sometimes those are difficult to get out to the court order, but I'll be glad.
Okay, yeah, just let me know. I'll sign an order if you need it. Okay. Mr. Burbank, are you ready on Brandon Bell?
Brandon Bell?
You sure you're ready?
I did.
Yes. Is that okay if I just do it?
Yeah.
He's in a wheelchair. Hey,
Good morning.
good morning, you're right. I had 2 counts.
No, I think he's the only one. They're just confused on which one.
All right, I have it ready.
Good morning, Brian.
Good morning, sir. You're Brandon Bell? And this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true in a motion to revoke deferred probation, pled true to counts 2, 3, 4, 6, 7, 9, and 10. And there was not an agreement on probation for aggravated assault with a deadly weapon. And I've received that updated report. Has everyone had an opportunity to review that report?
Good time, Chad.
I have, Your Honor, in addition to some medical documentation that Mr. Burbank has provided.
Was that provided to me?
Not,
Okay. I'm sorry.
probably not.
Okay. What should it have?
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
Uh-huh. I don't know what you're talking about. Yeah, I mean,
These are medical records from Spindletop.
okay,
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working,
okay,
which I think are factors that need to be addressed.
Probably in addition, Judge, if I may, to the fact that you were called the complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know
Okay.
that's been a concern, but had some difficulty with that portion of the case.
Okay.
And if the court would also remember, she was expecting another child, they are expecting another child. And
Okay.
she's
So
also,
what, go ahead and make argument and then I'll,
she's also controlling the checking account. He's getting settlements and he's providing the money to her for the children. They still have a house together. But he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, had some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation. He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, and she does have the funds that he has to be able to give to her. But if there is some program that he can have that's outpatient to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now in November, but the problems have been going on. But he does need to go back to Spindletop. He does need to say this is what you do or not. I mean, according to the pre-sentence report, he is reporting. It's not like he's not reporting. He's trying to pay or has been paying and trying to do stuff. I think he just needs a little bit of a correction and see whether or not they can do it. And couple all that, I've had extensive conversations with his wife. I've tried to tell her the way it has to be as of yesterday. We've talked over the phone in the way that it would have to be in reference to separation until they learned how to possibly get along together. So that's what we're asking for, Your Honor.
Ms. Malvino?
Judge, would the court like to hear evidence with respect to counts 1, 5, and 8? Ms. Lopez?
I mean, I guess it kind of depends on the.
Just in the context of what she has to say.
Yeah, for sure.
I call Ms. Lopez.
Ms. Lopez, if you'll raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you may proceed.
Ms. Lopez, would you please state your full name for the record?
Rachel Lopez.
And how are you employed?
I am the high medium risk officer at adult probation here in Jefferson County.
And are you the supervising officer for Brandon Julius Bell?
Yes.
And do you see Mr. Bell to your left in the wheelchair?
Yes.
I'm going to record reflect. Ms. Lopez is identified as the defendant.
The record will so reflect.
As a condition of his probation that was granted by this court back in April of this year, 2025, was he given certain terms and conditions that all probationers are to follow?
Yes.
And specifically, you've had an opportunity to review the motion to revoke that was filed back in July.
Yes.
In account number 1, it alleges that he failed to immediately report to you his or her contact information in violation of condition. Can you explain that to us, please?
There were multiple instances throughout the time that he was reporting where I would attempt to call the number he had provided at a previous office visit and would not be able to reach him. So then I would have to then search through his associates to find someone else who would answer, who would then say, we'll let him know you called. And so it's standard in our court orders that offenders are supposed to keep their contact information updated due to the fact that most of the time I cannot give out certain information to other people due to confidentiality.
So it's obviously very important that you're able to reach him and advise him of the conditions of his probation center.
Yes, we need updated phone numbers, addresses, things like that, so that we can specifically talk to the defendant.
And he pled true to additional allegations, including providing some dirty UA specimens being out past curfew. Was he ordered by the court to provide all records and documentations as required by you to you as his officer?
Yes.
And did he do that?
Yes, whenever it applied in regards to like spindle top, yes, those type things. I haven't had any kind of paperwork in regards to the settlement that Mr. Burbank has referenced, but I also recognize that that may be a recent thing. And so that may not be applicable yet, but otherwise, yes.
So some things you're able to verify, but yet others you are not, which is why you felt it important to include the motion.
Correct.
And additionally, in allegation number 8, did he admit to you the adulteration of his UA analysis on or about June 30th of 2025?
Yes, when he submitted that urine analysis that date, it was clear in the cup, and I did make a note of that in my chrono. It should be noted that even if someone is extremely hydrated, their urine is not crystal clear. And so when I specifically asked him in the offices at that date, did you do something to make it be negative? He said yes. And so while the drug test reflects negative, he admitted in the office visit that he had taken something, drank something to adulterate his urine.
And in fact, you and I have had a lengthy conversation in the past about his use or suspected use of K2 synthetic marijuana, which lends to possible negative UAs when in fact he would be positive just due to the nature of that synthetic.
Yes, Ms. Strother, our UA tech, has explained to me that K2 is a difficult drug to drug test for because much like the flu, there are multiple strands of K2 drugs out there, and our drug test can only specifically test for one type. And so if he had not used that specific type, it would test negative. And so the incident reports that I received through Beaumont PD indicated that the effects that they were seeing in their reports indicated synthetic marijuana use.
And that information is also reflected in your update to the court, correct?
Correct.
With respect to how his behavior appeared to be altered, involving odd hours, showing up at odd places, attempting to contact the complainant, et cetera, regardless of whether or not they mutually agreed to do so. And I believe your recommendation is very well thought out and very well put in the updated PSI. Do you have anything to add to the report?
I do not at this time.
I have some questions.
Yes, sir.
Ma'am, did you ever get his records from Stone Temple?
I believe so, yes.
And was he under medication?
Not during the time of all of this taking place. I know that since he was out on bond, I believe he went to Spindletop as of August 11th, and that was when he began having his medication the way he was supposed to.
In your report, you stated in the first or second paragraph that while the defendant does report as directed, he has made basic efforts towards paying his fees, correct? So he has been reporting to you.
Correct.
And then you also started receiving phone calls from the victim. Did you have any dealings with the victim at all? Were you here the last court hearing?
I was.
She didn't act very rational either, did she?
Not often, no.
And do you realize that they are expecting another child?
Yes.
And how many other children do you remember?
I believe they currently have 3 children together. I believe this is the 4th.
If I told you that there was a settlement to Scott Brown in reference to the motor vehicle accident that took his leg, he wouldn't disagree with that.
He told me that at the jail when I did my PSI update.
And he's getting monthly, I guess, settlement checks or quarterly settlement checks, in which the wife does have access to his account.
That I don't have any knowledge of.
You did also receive telephone calls from his mom, correct?
Correct.
And basically, she said that he's talking out of his head, he has mental health issues, right?
She did at one time, yes.
She didn't know, well, has to be between April and now, right?
Yes.
Because it was put on.
Specifically whenever he was out on bond.
Okay. He did appear, or direct, to be kind of delusional state, correct?
Yes.
Unable to remember, reference to taking medications or injecting, so he was on some type of medication, correct?
Correct.
And that one of his problems is that he has to learn how to remain on his medications in order, from Spindletop, in order to, I guess, try to live life normally, correct?
Correct.
Nothing further.
Anything else, Ms. Buffino? I don't know yet what I'm going to do, but is there any reason based on the injury that Mr. Bell could not go to special needs safety? Is that something that would prevent him from going?
I do not believe so.
You don't think so? You don't think so?
I think there are people that have gone to Spindletop that are
Sure.
in wheelchairs and things of that nature.
Yeah.
I said Spindletop, I'm sorry, safety.
Yeah,
So I think he would still be able to go. I think it would be under special needs.
right, that's what I would,
Yeah.
if that were an option, it would be special needs because that would address both
That
of the.
addresses mental health also, Jeff.
Yeah, that's what it's for. I mean, and here's the thing. I think a lot of the mental health is because you're using synthetic marijuana. I mean, that's gonna, so. Ms. Malfino, anything else?
Judge, I think you have a lot of information before you end your decision. I do think it's important, and I didn't want to hide behind the fact that we have had the issues with the complainant that she did come and testify.
And that's the only thing that's keeping me from doing probably what needs to happen.
But I don't have an interim update with respect to her.
Have you heard anything?
I have not heard anything since all of this happened. The reality is she's called me multiple times and complained and said that Brandon's here and she wants him gone. But Ms. Lopez, please don't send him to jail. She is very back and forth about it. My largest concern, Your Honor, is that the offense that the defendant is on probation for is extreme. And my biggest issue in truth is the fact that Mr. Bell does not take any responsibility for any of it at all.
I don't disagree.
Can I just have one question, Judge? Did this accident happen after
When did your accident happen?
November 4th.
of last year?
Yes, sir.
Of last year?
So all this has happened since he's been on probation.
Was this
Prior.
before? Was that prior?
His
to
accident
his
was
accident?
prior to when he was placed on probation.
Right.
No, but how about the incident itself?
Oh, the underlying offense?
Yeah,
April of last year. So the underlying offense was prior
prior to his.
to the injury, but the injury was prior to probation where he's still, I mean, regardless of you can still do things to injure someone, to harass someone, to put someone in fear with or without a leg. And that's what he's done. That's what you've done. Still make babies with her. I mean, I don't know. I mean, that she was pregnant. The whole point of this is you beat the crap out of her when she was pregnant, and now,
Third child,
and now we've got the fourth.
correct.
Judge, would you like me to do a notice call for her and see if for some reason she showed up today and
Sure.
court needs to speak with her? Adriana Bell?
Can we do a call for,
Adriana Bell?
I don't know if that's gonna help either, though. We've done that before.
And I don't know if it's a situation where it's the court needs to protect somebody from himself.
Do you want to reset it so I can possibly
I don't think it's gonna matter. I mean, she's been here before. I've ordered,
No response,
I think I have her mother's here.
But there was a no contact, and now we have another baby. So obviously there was contact.
Can I address that? From what I found out, Judge?
I don't need Snickers from the gallery.
I'm not calling them as witnesses. Every time they got mad at each other is when she got on the phone.
But she got on the phone, but that's him blaming. He beat her. You admitted to beating her. So she's probably scared when he gets mad. And then it gets okay, and then it gets mad. And he doesn't know how to get mad without beating the crap out of her.
I didn't get that indication, Judge. She's been to my office every other day. She's called. I mean, it's really,
I'm not in disagreement that Ms. Bell is also the problem, but my biggest concern here is their children.
separation.
Yeah.
I don't care if they stay together or not, admittedly, frankly.
Yeah.
I'm more concerned about the children involved in this case because of the violence that they're being subjected to. Whether or not the two of these adults can reconcile is between them, but there are children involved that I am extremely concerned about.
I agree. All right, here's what I'm gonna do. Mr. Bell, I don't feel like I have any other choice at this point but to protect your children and to protect your, I don't know if y'all are married, girlfriend, wife, mother of your children from you. I understand the mental health issues. From what I can tell, most of those are self-induced because you were using K2.
It haven't been an incident since I've been on probation.
That's not true.
I haven't had no abuse case since I've been on probation.
Okay, so you haven't abused her, but you weren't even supposed to be around her. I gave you don't talk over me, because y'all I told you when I put you on probation that she cannot give you permission to violate my order.
Yes, ma'am.
She can't say, it's okay, come on over.
She came to my house. I was staying in the house. She wasn't staying there.
Lock the door, kick her out. You're the one that's gonna go to prison.
She said that she called the laws to kick me out, and you said it still was an issue. She called the laws to kick me out. My mama came and got me, and I've been staying with my mama. I ain't been around her. She been calling the laws on me every time she come to my house. I paid $100,000 cash.
Why are you still having sex with her and having babies?
That's early on.
Early on when? We've only been doing this for 6 months. You've had 6 months, and all this has happened in 6 months on probation.
It happened 3 months because she finna have a baby next week. 3 months before I was on probation.
So what if she shows up at your mom's house?
She's not gonna show up over there. She know her and my mama don't get along.
Probably for good reason.
I would represent to the court that there is a problem there, Judge, because even when we talked about possibly with him seeing the kids without her at mom's, and that wasn't a possibility. There's something between her and the mom, his mom. And I know his mom, his brother has gotten in trouble. She has a very stable job at a bank. She's very straight-laced. His brother was the one in the West End that was burglarizing cars, and the owner stopped him and shot him about 8 times on the road and left him there. But she is very straight-laced, and she just couldn't get off of work this morning because of the bank.
So,
But he needs something, Judge. I mean,
well, but we tried to give it to him.
well, I'm talking about.
I have money now to pay for my battery class too. I have money to pay for my battery class and pay off my probation.
I'm not as worried about you paying off things as I am you having continued contact with her.
I'm not gonna be in contact with her anymore.
Is there a way, Judge, to put him on a GPS and reset this for 60 days?
No, I'm going to make my decision today because I'm absolutely, if I leave him on probation, he's going to safety, period. So we're not going to get out and see how we do and take that chance without having some kind of treatment up front. I don't know. Y'all hold on a second. Just don't take them far. For some reason, Anna, when I pull up the version that should have my notes on it, it doesn't have anything on it. So I don't know if I didn't save it. I have the prior version and the the new version. I printed out that new version and it doesn't have it. The date and all that. So I might need to go back and handwrite something from that date, but just remind me I put a sticky on this. Okay, let's see. Ms. Holmes on Samuel Harmon?
Yes, sir. Samuel Harmon.
So, side note on him, his dad called me and said he filed a grievance on me, but I'm still gonna represent him. But he apologized for filing it because he said he didn't know I was coming to visit him that day, yeah.
Okay, I'll follow up.
The joys of what you do.
Yeah.
Good morning. Are you Samuel Harmon?
Yes, ma'am.
And this is 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And Ms. Holmes, what is the announcement?
Yes, Sharon, if we could get one more reset. We did receive another offer from the state today that I would like Mr. Harmon to review with his family. And also I'll come out to visit with him as well so we can make a decision by the
All
next
right.
Monday.
I'll reset one more time. Any issues?
Just, Your Honor, that was a 12-year offer that's going to remain open until the next court setting.
Okay.
Withdrawn.
Okay, so Mr. Harmon, it sounds like there's an offer that's on the table that they've going to keep open until that next court date. Make sure you visit with Ms. Holmes about it, visit with your family about it. Sounds like there's not any more negotiation. The offer is what it is. If you want to take it, we'll take care of that when you come back. If you don't, you want a trial, we'll get your case set for trial. Okay, you can go back with the bailiff.
Thank you, Your Honor.
Brittany Litchfield,
Yes.
would y'all, I'll print the first one if you'll print the second one, please. Is Burbank still in here?
Yes.
Mr. Burbank, do you have somewhere else to be?
No.
Okay, I'm just gonna give me just a minute to
Yeah,
do.
I was supposed to be in hard guy. I'm not going back.
Okay,
Take all that.
okay, thank you. Good morning, are you Brittany Litchfield? Give me just a second to get this printed out. And will your client waive the formal reading of the motion in each case?
Yes, Your Honor.
Ms. Litchfield, in cause number 21-37098, I have a motion to revoke your community supervision. Shows that you were placed on probation December 12th of 2022 for the state jail felony offense of abandoning a child, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Judge, we'll still open, I guess it's 6 and 7 on each motion and just proceed on 1 through 5.
In each motion, 1 through 5?
Yes, ma'am.
It's okay. All right, and then in cause number 21-37099, I also have a motion to revoke your community supervision. Shows you were again placed on probation December 12th of 2022 for the offense of abandoning a child, and that was also a 2-year term in state jail prison that was probated for 5 years. Is that also correct? Each of these cases, the state has elected to proceed on counts 1 through 5 in the motions. They each allege in count 1 that you violated your probation by failing to report to the probation department as directed October 15th, October 31st, and November 14th of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 in each case alleges that you failed to immediately report to the probation officer your current address. Is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service hours that were required. Is that true or not true? And then count 5 alleges that you failed to provide verification of entering and successfully completing the parenting class. And is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts in each case because they're actually true? In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Litchfield is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 21-37098, revoke your probation and reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25-37099, also find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with that agreement to a term of 12 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am, and thank you for being here.
On bail, there is one in there
There
that
is.
says revised, yes. You must have not saved it, or.
I must have
didn't
not.
save it, and then I must have printed and
Got
gave
it.
it to you.
Okay.
So there is, do you need it?
I can, yeah. Yes. Maya Sparks, Ms. Holmes.
I'm not gonna say yes to this. Yeah, just for the mental storage, I don't know. Okay. Sorry.
Do you think we'll get a date before Christmas?
Probably not. I get to speak.
Good morning. Are you Maya Sparks? Yes, ma'am. And will your client waive the formal reading of the indictment in each case?
Yes, sir.
Ms. Sparks, in cause number 25, DCCR 0145, you're charged with the third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Speak up, please. And then in cause number 25 DCCR 0146, you're also charged with a third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases is for a 6-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Sparks is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later date for sentencing. Mr. Nichols, what is the state's position on bond?
Judge, I'm a little concerned about a PSI bond because of the way these cases occurred. There might be an issue that I do anticipate she at the very least being placed on mental health caseload. I don't think it's a competency issue. I've discussed it with Ms. Holmes, but I don't know if the court's going to decide that either an ISF or safety program is in the best interest here.
Okay.
The facts in this case involve threatening staff at a school, so it gives me a little bit extra concern. And there was one jail incident in the last week that gave me a little concern as well.
Okay.
Yes, Your Honor. So Ms. Sparks and I've spoken with her mother. Her mother is here. On this particular incident, there was a episode. She had a mental episode where she was not on medication at that time. She is compliant on medication now.
Okay.
And we are asking, her mother is taking care of her child. Her child was attending that school that she went to. And so I do feel that if she stays on her medication and stays compliant, that she will be okay. And so we were asking if the court would consider a PSI bond.
I guess the concern is without the probation order where, has she been to Spinal Tap before have you gone through Spinal Tap before? You are a Spinal Tap patient?
She's diagnosed bipolar and major depressive disorder.
Okay. So what I'm going to do, Ms. Sparks, just kind of based on also time of the year, I'm going to reduce the bond, but I'm going to have some very specific conditions on that bond. And you're going to have to follow those conditions Exactly. If you don't, because you're going to have to give Ms. Holmes proof that you're doing some things that I'm going to order you to do. And if you're not doing those things, then I'll issue a warrant for your arrest. We'll get you back in custody until that pre-sentence report's done, and then we know what everything is that you could potentially need. Was there also any type of, or is there any kind of drug issue, or is it primarily mental
It was
health?
just mental.
Okay, so Ms. Sparks, I'm going to reduce your bond in each of your cases to $2,500. If you make those bonds, the conditions of the bonds are that you immediately have an appointment, make an appointment with Spindletop, that you give proof of when that appointment is to Ms. Holmes. So I'm saying the day you get out, you make the phone call, you set an appointment, and Ms. Holmes needs to know when that appointment is. You don't wait a week to set the appointment or 2 weeks or anything like that. You set it the day you get out of jail if you make the bonds. Does that make sense? In addition, I am ordering that you remain on your medication. So now it's not just whether you want to or you feel like you need to, it's a court order. And if you don't do it, you're back in custody. Do you understand? So is her mother okay with her living with her? Where's mom? Thank you, ma'am. And thank you for being here. So I'm going to order that you remain living at your mother's house. You can't go spend the night anywhere else. You can't go anywhere else. You stay there. You go to Spindletop. You get yourself back on track so you can be fine and do this probation and not have any issues. Does that make sense? You are not to go to any of the schools wherever your child or children are going to school. You are not allowed to go there, period. Do you understand? Okay. That's not until I order otherwise. So for now, you cannot go to any school that they are attending. Okay? If somebody needs to pick up and drop off, that's going to be her or someone else. If there's a school program between now and when you come back, I don't care. You don't get to go. Do you understand how serious I am about that? Okay. Any other conditions that you feel like?
I think that will cover it, Your Honor.
Okay. All right. We'll see you back at sentencing. You can go back with the bailiff. Okay, I'm writing it all on my docket.
Here, I was gonna say,
So I'll write it again.
you don't have to.
Here, just keep it to the side and I'll do it. Remind me. But I did write it all down.
Okay, thanks.
I redid the paperwork on mine, Judge.
Okay, thank you. Mr. Kimler, what is the announcement on Jeremiah Branch?
I don't know what you mean, once, but
Okay, I'll hold it and take care of those when they're ready. Mr. Lewis, I was holding Russell Bean.
Just that one, I've gone next door to check, see what Mr. Cole got.
Oh, okay.
But he hasn't, he hasn't.
We're
got
waiting
it.
on that. I need to make that note. Okay. What about Denzel Spikes?
yeah, that was complete.
Okay, I'll take care of that when it comes through. Let's see, on Cecilia Delaney, did y'all get her? Let's take care of Miss Delaney, Mr. Parker.
Forgot about that one.
And this is one where they say outpatient, but I don't have,
Do we think she needs to go for longer than the 120 days?
well, it'll be a civil commitment today for a year. So that's why we had to bring her back, because that was just for the 120. And so now I can do the civil commitment for the 1 year. And even though it's recommending outpatient, I'll make it inpatient so that, because we don't have an outpatient.
All the way down number 78 on the list to be done.
Hey, you?
I don't
need
know.
one.
I'll go for a while. Yeah, why not? Is it a state jail felony or is it a third? We also need to watch out for
statute.
Okay. Yeah.
Because it doesn't look as if it's a public danger.
Right.
Thought we just did something September.
This one we were trying to get earlier.
Yeah. Oh, that's right.
No, why they have this journal? That's too big.
Sharon would have done it first try.
All right, this is cause number 24, DCCR 1386, and are you Cecilia Delaney? And Ms. Delaney is in court, was previously found not competent to stand trial, was transferred to the John Dunn Behavioral Science Center for competency restoration for a period of not to exceed 120 days. I have received the report from them, and we'll take judicial notice of the court's file, including that report. Included in that is the trial competency evaluation report, which was prepared by Dr. Mary Ann Robinson. The opinion in that report is that Ms. Delaney is still not competent to stand trial, and that further treatment would be required for competency restoration. In addition, there is a forensic psychiatry report that was prepared and by a Dr. Selleck, S-E-L-E-K. Again, the finding with him is that she is not competent to stand trial. Additionally, we have a physician certificate of medical examination for mental illness from Dr. Selleck. The finding in that is that Ms. Delaney does not meet the criteria for inpatient commitment, but meets all of the criteria for an outpatient commitment, with the specific findings that the nature of the mental illness is severe and persistent. As a result of it, if not treated, that she would experience deterioration and the ability to function independently. And in addition, we have a second physician certificate of medical examination for mental illness from a Dr. Lee. The finding is the same in that Ms. Delaney meets the requirement for outpatient commitment based on the nature of her mental illness being severe and persistent, and that if not treated, will experience deterioration and the ability to function independently. That's it. It's another one. Okay, so that being said, well, is there any other evidence with regard to competency?
No, Your Honor.
Not from your state.
So obviously, you guys both know we do not have an outpatient treatment facility in Jefferson County.
Right.
We don't have a jail competency restoration or outpatient competency restoration. So that being said, I have no choice at this point but to find that Ms. Delaney is still not competent to stand trial, and find that commitment inpatient would be required because we do not have outpatient commitment facility, because the nature of her mental illness is severe and persistent, and that if not treated, she would not be able to function independently and live safely in the community without the court-ordered treatment services. And so I am going to order a civil commitment for a period of not to exceed 1 year for competency restoration at the appropriate facility. If there is restoration prior to that, they'll let us know and we'll get Ms. Delaney back. Otherwise, we will wait for their report and have a hearing at that time. Ms. Delaney can go back. Ms. Perazzo, are you ready on Trevon Alexander? Good morning, sir. Are you Trevon Alexander? And Mr. Alexander, I'm sorry?
I said good morning.
Good morning. And so Mr. Alexander is charged in cause number 25 DCCR 0831 with murder. And Ms. Perazzo, what is the announcement?
Your Honor, if we could have just one more short reset so Mr. Smith and I can try to work out an agreement. We have received an offer.
You've received all the discovery?
Yes, ma'am. There are no discovery issues.
Okay, so what I'll do is this will be the final reset. I'll give you some time to do that. Mr. Alexander, at the next court date, if you guys have reached an agreement, we'll take care of it on that date. If not, we'll get your case set for trial. All right, you can go back with the bailiff. Well, that's great, except that he just got it all done.
Okay, I'm just.
Okay, I'll get to it in just a second. It's not even here yet. Okay. Mr. Burbank, on Destiny Williams,
Yes, Your Honor. She's in the back.
and Mr. Kimler, I'll get to it as soon as I can.
Want to take it?
Nope. I don't have it anyway, but
I don't have the paperwork. Never mind. We're pleading.
For what?
We're pleading to counts 1 and 3.
okay.
You want paperwork?
I don't know. Do I want paperwork? Is it for what's it for?
Okay.
Yeah. Yeah.
Just,
Yeah. I threw you off on the other one. He's gonna have to do paperwork with her.
you didn't throw me off.
I mean, I know it's a new thing, this whole paperwork silliness when we have to do something, but you're getting old. Okay, let's see. So how many are we doing on Branch? Jeremiah Branch? 8-2 and 8-5. Handle.
Oh, these came up with Judge. I emailed you last week.
Good morning, are you Jeremiah Branch? Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Mr. Branch, in cause number 25 DCCR 1382, you're charged with the second-degree felony offense of assault on a peace officer from September 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? And then in cause number 25, DCCR 1385, you're charged with the second-degree felony offense of robbery from September 17th of 2025. And how do you plead to that charge? Are you also pleading guilty freely and voluntarily? And because you did what they've charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreements in each of your cases are for 10-year deferred probations, $500 fine in each case. You would be required to follow all of the rules and conditions of probation. And there would be dismissals in cause numbers 25 DCCR 1383 and 1384. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Branch is not competent?
Your Honor, I believe he meets the legal standards for no competency.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back later for sentencing. Mr. Smith, what is your position with regard to bond reduction based on the nature of these plea agreements? I just printed out a PC.
No.
Let me take a look at this one. Good grief. Okay, so Mr. Branch, is there any criminal history? How old are you?
It has 32.
There is criminal history?
One state jail judge.
I think I'm not going to adjust the bonds due to the nature of the offense. I have taken a look at the probable cause affidavit. I just want to make sure that there's a substance abuse assessment done, make sure there's no issues with that and or any mental health issues that would need to be addressed. If we can also take a look at any mental health issues so that I know at sentencing if there's any other requirements that I would want to impose before release so that we don't end up with this kind of issue again. You can go back with the bailiff. Denzel Spikes, Mr. Lewis. And no paperwork on this?
Yes, shoot paperwork on.
All right, just have a seat, and I don't have it yet. Let's see, we took care of Lazo, right? Okay, give me a minute for, Mr. Rojas, you have a Byron DeQueer, 2 cases.
Yeah. This is from the 8th month.
I'll print the first, if you can print the second, please. Just a second. Good morning, are you Byron DeQueer? Will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Give me just a second.
We can narrow down some of the counts.
I cannot hear you.
We can narrow down some of the counts on the M12.
Okay,
There's like 13 counts.
what do you want to go forward on?
We go for first 7.
Okay, state's going to proceed on 1 through 7 in each case. Okay. And Mr. DeQueer, in cause number 23, DCCR 1448, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 2nd of 2024 for the second-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct? Yeah, it's just correct that you were placed on probation on that day, right? Are they printing?
open paint dry.
Huh?
Open paint dry.
I feel like yours is closer, but it takes longer to print than mine.
And some of that is just take it out and.
Do we need a new print? What do we need to do? Everything? We need a new TV. We need a new printer. We need new computers.
Thank goodness it's Christmas.
We need new tablets.
Just ask Santa.
Unfortunately, Santa is on the 4th floor of the old courthouse, and I missed that opportunity during budget season to ask for all this extra stuff. Okay. Okay, now, in cause number 23, DCCR 1449, I also have a motion to revoke your unadjudicated probation. This one also shows you were placed on probation July 2nd of 2024 for that same offense, assault on a peace officer, second-degree felony, and that was also a deferred probation for 10 years. Is that correct? Each of these cases allege that you violated your probation, and the state has elected to proceed in counts 1 through 7 in each. Count 1 in each case alleges that you provided a urine sample July 14th of 2025 that tested positive for methamphetamines. And is that true or not true?
True.
Count 2 in each case alleges that you provided a urine sample August 12th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true?
True.
Count 3 in each case alleges that you provided a urine sample August 25th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true?
True.
Count 4 in each case alleges that you tested positive August 26th of 2025 for methamphetamines and amphetamines. Is that true or not true?
True.
Count 5 in each case alleges that you tested positive September 10th of 2025 for amphetamines, methamphetamines, and ecstasy. And is that true or not true?
True.
Count 6 in each case alleges that you tested positive September 16th of 2025 for methamphetamines. Is that true or not true?
True.
And then count 7 in each case alleges that you failed to conduct yourself in a courteous and professional manner at all times when interacting with your probation officer, and that you were argumentative, raised your voice, and became verbally aggressive toward them. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're actually true?
True. Yes, ma'am.
I have here on the tablet some documents in each of your cases that have your signature on them that the state has marked as exhibit number 1. Before you signed those documents, did you go over them with Mr. Rojas? And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted. Is there any evidence that Mr. DeCuire is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. In cause number 23, DCCR 1448, find sufficient evidence to find you guilty, and at this time, find you guilty. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1449, also find counts 1 through 7 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you In each of your cases, the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Taylon Douglas, Mr. Rojas, the sentencing.
Taylon Douglas.
She says, I get it.
What would you do if a judge offered you a second chance? Not with punishment, but with encouragement. This courtroom session wasn't filled with shouting or dramatic outbursts. Instead, it showed something just as powerful. A judge determined to help people turn their lives around while still holding them accountable. One of the first defendants appeared before the court after reaching a plea agreement in an operating while revoked case. Because he was already participating in an intoxicated driver intervention program, the judge worked with his schedule, even arranging a Friday afternoon sentencing so he could finish his work week before reporting to jail for the required weekend sentence. It was a reminder that accountability and compassion can exist at the same time. But the hearing took an even more emotional turn with another defendant who had been struggling to get his driver's license back after an OWI-related revocation. He explained that life had changed dramatically. He had been forced to move, lost his job, and was trying to rebuild while dealing with the costs of getting his license restored. Instead of rushing to punish him, the judge carefully walked him through every option available. She even offered to redirect money already posted with the court toward the programs he needed to complete if that would help him finally get back on the road legally. Then came the moment that changed the entire hearing. The defendant revealed that he had remained sober for more than a year. The judge immediately stopped to recognize the achievement.